Here we go. How's my audio coming in?
I can hear you.
So if you could mute your mics and we will be live in 1 minute.
Good morning, and a very warm welcome to our global audience for today's webinar, Judicial Disputes over Standard Essential Patents in Colombia. Colombia's courts have become a fascinating forum in the global SEP wars. In a short time, they've delivered bold rulings, sparked a major regional legal conflict, and forced the world to pay attention. So what did we learn, and more importantly, what happens now? It is now my distinct honor to introduce the exceptional panel of experts who will guide us through these complex issues. Juan Camilo Contreras Jaramillo is professor at Javeriana University in Bogota and currently serves as head of the private law department. He holds a PhD and has been working in the university for more than 15 years. David Katz is an attorney and advisor at PacTech Law. He previously worked as a senior associate at Wilmer Hale and clerked for the Honorable Todd Hughes of the U.S. Court of Appeals for the Federal Circuit and for the Honorable May DiAugustino of the U.S. District Court for the Northern District of New York. David I'm so sorry. Enrico is a professor of law at the City St. George's University of London. He teaches, researches, and advises in the field of IP law. His research agenda is wide-ranging, focusing on the intersection between IP, international trade, and new technologies, including AI and standards. He is the author of numerous publications on several aspects of IP law, and in his spare time, Enrico enjoys listening to and collecting vinyl records. Laura Angel Jaramillo leads the IP litigation and strategic advisory team at Brigard Castro. She graduated as a lawyer from Universidad de Rosario and has a postgraduate degree in commercial law from Universidad de los Andes and has an LLM in law and technology from Tilburg University in the Netherlands. In 2022, she led the defense of one of the major cell phone manufacturers in an SEP case in Colombia. And during 2024, her team also worked on over 24 litigations concerning alleged SEPs. Laura is a super fan of historical romantic novels and has read over 30 in just 1 year. Last but certainly not least is Carlos Olarte, founding partner of Olarte Mure. Carlos filed the first SEP assertion campaign in Colombia against Apple on behalf of Ericsson, followed by campaigns against Lenovo and Transition. He is a biomedical and mechanical engineer from Duke University and a U.S. and Colombian lawyer, attending Chicago, Kent, and Javeriana law schools. Even though Carlos works on cutting-edge technology, he is still a huge BlackBerry fan. It is also Carlos's birthday, so please join us in wishing him a happy birthday. We know nothing quite says party like a robust discussion of standard essential patents. So to kick us off, Enrico, could you please summarize the current global SEP litigation landscape and what are the most dominant strategic models or camps that have emerged, and how do those fundamentally differ in their approach to core issues like injunctions and FRAND rate setting?
Thank you, Amanda, for the introduction and for asking me the first question. I mean, the global SEP landscape is increasingly fragmented into, we could say, a few dominant models, each using injunctions and friend rate setting in different ways to gain some sort of leverage. For example, first, there is a strong injunction, narrow friend camp exemplified by mainly Germany and now the Unified Patent Court, the European UPC, where basically courts readily grant injunctions, often, once validity, infringement, and the basic FRAND willingness tests are met. So these jurisdictions actually usually avoid detailed rate setting and instead prefer to police only whether each side has behaved as a willing licensor or as a willing licensee, leaving royalty levels to private negotiations under the shadow of an injunction threat, often. So this model often and inevitably gives SCP holders powerful bargaining leverage and makes them attractive pressure forums in global licensing campaigns. So this is the first model we could. Then a second model, I would say, a global rate setting conditional injunction camp has also emerged, led by the UK and in a different way also China recently. So as we all know, UK courts assert jurisdictions to set global front rates and then condition a local injunction on the implementer accepting those court-determined terms and conditions, as in, for example, in the seminal case Unwired Planet. On the other hand, Chinese courts are increasingly asked to set global or at least portfolio-wide front terms and have combined that with the use of anti-suit injunctions, which have triggered as well a WTO action. Third, the third model we can think of is exemplified by the US, which represent a more antitrust sensitive methodological camp, where some courts have become reluctant to grant SEP injunctions and instead focus on developing analytical frameworks for front damages and negotiating conduct. So this approach seeks to curb hold-up risks by treating injunctions as not normal, as not automatic, and using detailed damages and conduct analysis to guide global negotiations. So altogether, and I conclude with this, these camps create a sort of strategic map in which SEP holders and implementers select forums depending on whether they seek injunction-driven pressure, a court-imposed global license, or a more cautious, competition-oriented front methodology. This is, in short, the models that I see current underway.
Great, thank you. Juan, I want to throw it over to you. How would you characterize the Colombian approach to SEP disputes? And what is its core legal principle? What strategic strengths and weaknesses does this approach create for parties engaged in global litigation?
Well, thank you, Amanda, and I would like to thank all the guests that we have here at Javeriana University, at least virtually. Hopefully, we'll have you soon physically here in Bogota someday. Well, I would rather think of the Colombian approach as an completely procedural one, like a procedural approach, a court-centered approach, rather than a substantive SEP or front disputes doctrine. This is because in the framework that Enrico just outlined, the Colombian courts have treated the SEP disputes largely because of injunctions procedures are being held here in Colombia. So the focus is entirely on whether the preliminary injunction could succeed or not in the country against implementers that are importing or selling or commercializing in any kind of way the devices that have the patents, the essential patents here in Colombia. So there not have been any discussions on the in depth on whether a front license should be or how should it be issued here in Colombia. The judges haven't dealt with that here in the country. So the core principle has been the procedural discussions around this, the preliminary injunctions that been dealing judges here in Colombia in different levels. So here right now we have an strategic country because in the global context, Colombia is a country where patent holders can have a very expedite injunction. It's very fast the way that Colombian judges deal with this kind of injunctions that are presented by the patent holders. In the other way, I think there is maybe a contradictory scenario for Colombia, because I would think, and this is a personal point of view, I don't think that neither the patent holders or neither the implementers would like a Colombian judge to be setting any friend terms here in the country. And I would say this can extrapolate to other developing countries. I mean, you have a contradictory scenario over there because you have a very fast jurisdiction dealing with preliminary injunctions, as has been shown in a few cases here in Colombia. judges in first instance and in appeal deciding very fast and very clearly about these injunctions. But I don't think that neither patent holders, neither implementers would like a judge to be deciding how much the license would cost, or in what terms the implementer could be having that license that the judge will decide on how to use it in the country. So it's a procedural approach with a contradictory ending, because in Colombia we don't see, I don't see at least any FRAND disputes in large being dealt in Colombian courts.
Wonderful. Thank you for that explanation. Carlos, I'd love to hear your perspective on the features of the Colombian system that most shape litigation strategy, and how might those incentives change under a more explicit proportionality framework. You're a litigator, so how have you seen this in practice?
Thank you. I think what makes Colombia attractive is indeed one, initially, the ability to get a relatively quick injunction based on a pretty front-loaded complaint involving, in our case, strategically, at least some discussion on the SCP nature, FRAND nature of what's been going on. In other words, a bit of the story of the licensing conduct and the negotiations. And although they weren't taken into account in the judge's discussions in the Apple case, as the campaigns have progressed, you see more analysis. But the ability to get to that quick injunctive relief is I think, something very attractive. I think another issue that also makes Colombia attractive is the validity issue. Invalidity is going to take a while to show its face in Colombia. There's a very strong presumption of validity that's formed by the delay that the pertinent judicial branch that will analyze validity will take to get around to analyzing validity. So it doesn't mean they won't get to it, and that eventually the parties won't try to attack validity, but so far that's been a non-issue for Colombia. So that certainly makes for another extra point for Colombia being attractive. And I also think, and this we started to see in the Lenovo campaign, even if you don't ask for injunctive relief early on, my timing is 12 to 16 months to get to an initial first instance decision that would involve permanent injunctive relief. So I think that's also another attractive feature. And in Lenovo, when the parties settled and, well, went to arbitration finally, we were 4 days away from an initial hearing. So I think part of the discussion was also, I think that was some pressure on the parties to get back to the table to discuss licensing. So I think those are the features that principally would make Colombia attractive, and this is not just Ericsson anymore, but other parties looking at Colombia as well.
Wonderful. Thank you so much.
Sorry, if I can just cut in about what Carlos was saying. I think he's completely right that Colombia's procedural framework does make it an attractive venue for litigants, particularly for patent holders. But I also think that there is this that is sort of there's sort of a bigger question of, as a matter of policy, is that good? If you were to have a legal system where you assert a patent and automatically get injunctions and get whatever you want, well, that makes the patents very valuable. That the question is, does that advance the goal of the patent system? And I've always found it disconcerting, the notion that invalidity determinations can take so long. And so someone is able to pursue litigation and even get a preliminary injunction over what is ultimately found to be an invalid patent. And I don't think that is a framework that either serves innovation or really advances sort of the national economic interest, because it creates effectively a tax on manufacturers bringing products into Colombia.
Laura, how do you see that from your perspective?
Thank you, Amanda, and thanks to Juan Camilo and Universidad Javeriana for the invitation. It's great to be here. I definitely agree with Carlos in many things, which is surprising for me since we've always been against each other. But yes, I think Colombia is attractive for stakeholders because of the tendency to have strong and early preliminary injunctions, because invalidity is very hard to litigate and very long to litigate. But I would add to that the possibility to have multiple parallel actions. So in Apple, we saw 13 cases. In Lenovo, they were, I believe, 9 against the Motorola local company, 9 against the Lenovo local company, and probably from 3 to 5 against 3 of the major distributors in Colombia. So that means that you disseminate the risk of judges basically denying a preliminary injunction. And well, that's basically very convenient to the subholder. I wouldn't say it isn't. It has therefore been portrayed as a pressured jurisdiction where all you want is to get a preliminary injunction quite easily and then go and set the real value of the dispute somewhere else, probably the UK, maybe the US, maybe China. We'll continue to see that. But I have seen worried clients touching the point that David was saying. If it were the case, if I had a factory in Colombia, then I will probably question myself if there is a place I want to have a factory to manufacture this type of goods in a jurisdiction that has been so aggressive towards implementers. I've seen it in terms of comments. So far, I have not seen any measure taken against this jurisdiction based on preliminary injunctions granted so far. But I also think that there is something we need to remember. I agree with Carlos, the judges' decisions have been developing, their analysis have been each time more deep. Each time they seem to understand and have a better grasp of the litigation as a whole. And we'll see how it comes this third time around. But I believe that each time they have more elements to make a decision that is very grounded, at least according to our local laws, which is what they should be doing. Whether or not that should be the policy we should be encouraging, I'll leave that to the policymakers. But as a general rule, I believe that it is getting each time more interesting.
Thank you for your perspective on that. And why don't I stay with you? What do you think the role of Colombian courts should be in those SEP disputes? Should they be limited to providing injunctive relief, or should they be encouraged or possibly required to adjudicate local FRAND terms to resolve the dispute?
I'll start by clarifying something. I don't think they ever been asked only to decide on injunctive reliefs. Maybe in Apple at the beginning, but it was quickly followed by an infringement lawsuit. So they were, at least in principle, asked to resolve and I'm quoting my counterparty here, an infringement over a Colombian patent in Colombian territory. Am I right, Carlos? And that is the reason why it is so, even though at the beginning the debate was around whether or not they've been granting injunctions, in principle, they should, the courts, I mean, should be looking at the expectative of deciding the patent infringement as a whole. that hasn't happened. I believe, as well as Carlos well mentioned, that the fact that the proceedings quickly advanced put pressure on the global negotiation, as it is something that probably neither of the parties want. But in principle, the court should be deciding on the basis that they will, or they've been asked to decide over the matter on the merits. Not on the global front rate, that has never been asked to them. I believe that it was the SIC in Apple that did consider many friend matters, and it said, I don't believe that the injunction should proceed, considering that this is a matter far greater from what has been portrayed to us here, very broadly and generally speaking. Should they be the ones deciding over a global friend rate? I don't think they have the experience nor the knowledge at this point to make a decision of that kind. And I don't think that our laws have the elements to allow them to take jurisdiction over that. But as I was thinking over your question, it came to my mind that maybe a local friend rate for the duration of the proceeding might be something feasible in terms of, for example, replacing the injunction that excludes the devices from the marketplace, and instead set a local friend rate for only for the duration of the proceeding. We haven't seen it yet, so it's just an idea.
Great. Carlos, do you have anything to add there?
Yeah, I mean, I think we're going down the, what does the public innovation policy want out of the patent system? I also work in the deep tech early stage, and the stories I have to tell regarding the US and being able to obtain preliminary injunction is horrid, after the AIA, after eBay, which basically says you got to sign over your IP to a big tech. So there is a strong movement not to go that way, to not let the pendulum swing that way up all the way. I think there's probably some work we can do regarding how the judges, and it's been happening, the judges have been taking into account some proportionality issues, which obviously is something that went up to the ending secretariat in the Lenovo case regarding what factors exactly and how far they can go. But I certainly think that the way we've structured the system right now is that it does favor the patent owner. And I think that's not necessarily a bad thing if you want to promote the pro-innovation image, which is something this government and prior governments have done. I think, we're probably talking about some fine-tuning that needs to take place. Regarding the validity issue as well, I think that's something that will also, be starting to move along. Our firm just recently invalidated a trademark under rather extreme circumstances at a very early stage. So I wouldn't throw away the possibility that eventually you can question the validity of a patent early on. Hasn't happened either. So I think this is also an issue of going into the specific, granularity of the cases. And I don't think it's as easy to get a preliminary injunction. And I also think that, judges are smart. They take into account the circumstances. We've seen some pretty decent analysis coming from the judges, either granting or rejecting PIs. And in many of those cases, they're trying to dig a little bit deeper. But like with any other jurisdiction, you start learning across different campaigns. And for now, Colombia is what it is, and I think the pro-innovation point of view is important.
Carlos, one thing I just like on the eBay front. I'm not sure I disagree. I'm not sure I agree with you that you're framing of it. Injunctions are readily available, even in the US, even under eBay, in the situation where the patent holders' use of the patent, they are practicing or have given an exclusive license for the use of the technology, and they are benefiting in that way from monopoly rights bestowed on it by being the only by having a unitary product with the tech. Where I think eBay interferes with the ability to obtain adjunctive relief is when a patent holder is seeking to license the patent. And the US case law has developed in a way to promote theories of apportionment that if you patent one part of a multi-feature device, you're not entitled to the profits from the entire device, only to the profits associated with that technology. And I think we've seen that now that eBay's coming on, is getting long in the tooth and coming in 2 decades. We can look at what the outcomes are from studies. There's an article by Christian Palmers and Brian Love that looked at the impact of eBay on innovation and found that the US continues to be one of the most pro-innovation economies that spurs a lot more investment. So there is always a balance that you need to protect intellectual property rights. I can see, particularly in areas like pharmaceuticals, where the company that develops the technology, either directly or through licensing, has a single product coming out, or in certain novel emerging technologies where there is not a sort of that aren't relying on a jointly developed platform. But I don't think the US's approach in eBay is sort of not on the side of innovation. I think the evidence, if anything, shows it has been encouraging and spurring innovation.
Sorry, Amanda. I just wanted to pick up what Laura was saying before, because it seems that Laura was hoping that Colombian courts start, for example, granting interim license declarations pending the trial. I mean, this is, as we know all, this is a recent trend started by UK courts last year, and I think that would be, I mean, allowing or requiring courts to determine at least provisional, or to help determine provisional local front terms. In my opinion, it would provide both SCP owners and implementers with a clearer path to demonstrate willingness and good faith in negotiations, maintaining access to the technology while still paying a court-supervised or determined royalty. In this way, I think a good compromise would be reached. Then, of course, German courts think otherwise.
Yeah. I completely, Enrico, I completely agree with what you're saying, as always. From the practitioner side, a lot of my work is actually involved in licensing negotiations behind the scenes. Most of our negotiations, fortunately, never reach litigation, and we're able to avoid that. But really, one of the things we see over and over is our clients are trying to say, how do we demonstrate our willingness? And I understand from the patent holder side, every delay or hiccup along the way can easily seem like an intentional tactic where the negotiator changes, but what the patent holder doesn't see is that the person who was leading the negotiations before you got a new job and left the company, or is taking sick leave, or is on parental leave. Technical discussions take a long time because understanding the patents, you're given a portfolio of 30 patents and you have 10 other licensing negotiations going on, and it's just churning and analyzing the material you're getting takes a long time. And so the ability to have a judicial framework to show good faith to the patent holder through an interim license while the negotiations are going on, or during the pendency of a judicial determination, I think would clear the air, and I think help licensors acting in good faith be able to see that their counterparty is also acting in good faith.
Yeah, just very quickly, my issue with country by country interim licenses is just, for me, that can quickly turn into a way to keep extending discussions. So, I mean, that's something I think more than just the German courts, breaking up and, turning it into a big piecemeal negotiation for Brazil, for Colombia, for Mexico, for Indonesia, for Egypt, for Morocco. I think that just becomes unmanageable. And it's certainly something that can be pursued, but I think it's something that some courts have already said it's not the greatest idea for the global discussion regarding the entire package. So that's something that, for me, just doesn't make too much sense from a local perspective. And again, I can't see a local Colombian judge hammering out terms and conditions um, under such a figure.
I
Yeah.
think Carlos, sorry, one off.
Well, very short. I would say that from a policy standpoint of view, it's very difficult. I mean, Colombian judges have never dealt with that many transnational effects of Colombian disputes, so they are not used to set global licenses, and it will be very difficult market-wise for a Colombian judge to fix a sum of money. In the other hand, I would say that interim licenses, I would agree with Carlos that makes very difficult from a local standpoint of view, but I think that it will make it very difficult from a global standpoint of view. If you see the market as a whole, um, uh, each country grading fees under particular and local sets of points of view or market understandings, it will differ a lot and vary from a great deal of possible decisions that are on the table. So from a global point of view, you will have the change of global commerce uh, being broken in little pieces that, as Carlos said, you will have a Colombian little market, a Brazilian little market with different kind of arrangements, and that there are not that very business smart for a company that is just dealing with the whole global change of commerce. So I think it will be difficult for everyone, implementers, patent holders, and I think Colombian judges will grasp that kind of problem and will be reluctant to set that kind of interim license.
So I agree with both of you in that it is not that a country by country approach is not necessarily the easiest way of doing this, but I think there is this element that we need to look at what the actual underlying law is. There are three issues in SEP licensing negotiations. First, there is the patent law. That is, the patent holder has a patent that they claim is essential and may or may not be infringed. The rights that go to that patent are territorial in nature. This is something that was enshrined in the TRIPS agreement, and the Latin American bloc, along with India, really fought hard to ensure that their territorial rights to develop and balance their own IP systems wouldn't be subsumed by the transnational treaty. So at that point, the idea that you can enforce a patent in a court globally, that is not something that is within any patent system. The next aspect of law that we're dealing with is competition law. The standard setting process involves horizontal competitors working together to to adopt a technology. And the very nature of that process means they are excluding competitors during the standardization process who get frozen out. And there is the FRAND commitment has competition routes to ensure that standards don't become a form of cartel-like licensing conduct. Then that again, competition law is a domestic territorial set of jurisprudence that is about domestic concerns, not international. Then there's the third aspect of law, which is contract law. During the standard setting process, the patent holders make a voluntary commitment to license their technology on either FRAND or RAND terms, depending on the organization, subject to different specific requirements. IEEE is different than ETSI and what's needed. But that creates a contractual obligation to which I think across all standards to license the patents on at least reasonable and non-discriminatory terms, to negotiate in good faith. Now, the implementer in that situation is a third-party beneficiary, meaning they have when they're just doing something, they have no contractual obligations yet. It's not until they exercise their rights as a third-party beneficiary that a contract that contract law between the parties emerges. Now, under contract law, that's where we get, as we've seen in the UK, the notion of global rate setting. It's not a matter of patent law that the rates are being set globally. And we saw this in Unwired Planet, which set the stage for global rate setting. Although Huawei was resisting the global rate, they had proffered a contract law defense, which in my view gave the UK courts the jurisdiction to set a global contract, because part of the FRAND commitment is to offer a global license. So until you have that contract law element emerge, if you are just dealing with patent and competition law, there is no predicate to globalize the licensing dispute, and it really is confined to the jurisdiction hearing it. Now, is that the most efficient? So it's definitely not. I think there are a lot of problems with it, but that's also the system we have. That is what all the members of the WTO negotiated for. If we want to move beyond that and not just for steps and have a more globalized IP system, then we need to actually have treaty law that establishes it. Yeah, sorry for going on there. I've been thinking about this a lot recently.
Oh, I'm sorry, Carlos, did you have something to add?
Yeah, I saw a little bit of what David is saying at the recent WIPO event last second semester regarding the discussion of the global negotiation. And for me, just thinking of Colombia, while I heard all these really smart people on the panels talking about this and whether the WIPO arbitration system is a good system or not for all of this. I mean, my thought is, again, and this, I'm trying to simplify things for many folks in the audience, which is while this discussion is being negotiated, or while a global patent licensing agreement is trying to be reached, which, like David mentioned, I think my figures are more than 90%, 95% of these cases never reach litigation. The ones that do, I think, have just very particular circumstances. And the question is, how long should I wait? How long should I be patient? In my cases with Lenovo, it's 13 years. Transsion, it's 7 years. Apple was immediate, but then it was a renewal. And the last time I renewed, they took me out 3 years waiting. So, the question is, can I always use PIs to force the other side back to the table? And no, there's probably limits, right? People always bring up 6.1 in ETSI, French contractual law, all the competition law stuff. But the 7 years makes sense, the 11 years makes sense. And obviously, I'm pitching my side, right? This is 11 years, it's 7 years, right? The other side's going to be saying, yeah, but we were, someone had a maternity leave and someone got switched out. And, excuses on both sides, but it's what the judge will decide and whether or not a court can force you to stay off the market. And it works. I can say it does definitely work when you get kicked off the market, when you have a big old sign that says you can only sell your earbuds. It gets people back to the market. And it's when it's really close to jury trial in Texas, it's an extra kick to get things moving. So I don't think the cases we're talking about here, at least for Colombia, are anything that could be characterized as unreasonable on part of the patent holder. So those are the ones I'm thinking in my head. I'm sure David and a few other folks, have other situations, not just Etsy cases, not just 3GPP, telecom, 5G, 4G stuff in their heads when we're talking about all of this. But I saw this discussion in Geneva too. And I think, some folks are like, no, we got to keep hands off and let folks negotiate freely. And I think there's, a lot of patent holders, obviously, and obviously a lot of pools that are saying, let's get to a quicker solution.
Carlos, I think one of the my pushback on that is that you had in the Lenovo case, Lenovo was actively seeking a rate adjudication with Ericsson in the United Kingdom, was willing to do one in the US. And despite having, and I think the length of that negotiation is complicated by several factors due to, that there's a more, my understanding is there's a more complicated history between the parties, given that Lenovo was a merger from Motorola, and there was there's a lot more going on in that history. But what we had is Lenovo was saying, okay, we want to take a license. We just don't agree on the price. Let's have a court adjudicate it. We can do it in South Carolina. We can do it where Ericsson brought the suit, or maybe in North Carolina. We can do it in the UK. Let's just do it somewhere. And the UK courts even acknowledged during the interim license determination that Ericsson's strategy wasn't to have a rate adjudication; it was to do everything it can to thwart it, and that was characterized as holdup, and so the ability to use collateral suits and injunctions to coerce negotiations, I think, is becoming less sort of a viable explanation for seeking an injunction in Colombia when there are firms now willing to set global rates.
I mean, the weird thing is they finally got to arbitration and accepted it in the settlement, right? So that was something that was proposed really early on. So I'm just wondering what the different terms and conditions of the arbitration were.
Well, I think arbitration, there's a whole range of things in arbitration. Having done both SEP litigation and SEP arbitration, the rules of procedure in arbitration are so bespoke than what the terms are. For example, what the party may say, okay, it's a binary choice, it's either our offer's friend or nothing, what the rules of evidence are. And there's a whole host of reasons where parties can get stuck up on it. One of the nice things about court proceedings is that they are sort of set in place. And I think the fact that they ultimately went to arbitration may also have been due to the fact that Ericsson didn't want to lose an appeal to the UK Supreme Court, where finding that they were an unwilling licensor, and the case seemed to settle right after Ericsson got its UK filings in, and after Lenovo had a reported complaint to Etsy. And then sort of at that point, everything sort of disappeared and the problem went away. Again, I can't speak for what the party's actual intentions and motivations were, but the fact that they went to arbitration it doesn't signify where the pressure points were coming from, just that at that point the parties found that it was better to take it off of the front page of IAM, the IP and other IP news sources.
I want to jump in and turn it over to Laura, because it seems like there's like a lot of uncertainty and a lot of tension in this particular issue. So given that uncertainty, is Colombia now a higher risk, higher reward jurisdiction for SEP holders, or does this present a new defensive opportunity for implementers that were not available before?
Thank you, Amanda. I think strong injunctions remain possible. I think, however, there is a great legal uncertainty and supranational scrutiny, increasing the strategic and reputational risks as to what we've seen in Colombia. But we've also seen very sensible and very analytic judges providing each time more knowledgeable decisions. And I think the system is becoming more and more defensible each time. I think tools such as the High Court of Bogota defending, and that is strongly defending the application of domestic laws, and in particular the General Procedural Code, preliminary injunctions should be only granted if proportional, if granted on the basis of necessity and effectiveness, makes a lot of sense, but also makes it more debatable. And I think that as we move on into different rounds and the judges start to grasp better the situation, more defenses will probably come into the picture. I mean, I'm imagining antitrust defenses, competition law defenses, all kinds of defenses that have been somewhere around the cases as a ghost, but maybe each time they resonate better into the judges' minds. And again, we'll see, but I believe that things are starting to get more balanced as we move forward.
That's great. Thank you. I also want to pivot to the tension within Colombia between the Andean Community Secretariat's ruling and Colombia Domestic Procedural Code on Injunctions. Juan and Enrico, I know you wrote an article on this very issue. Can either of you discuss your perspective and what you see as a path forward?
You want to start, Enrico? Okay.
You can go, Juan, and then I follow up. Yeah.
Okay. Well, I will characterize the situation here in Colombia as a very unique scenario, because as we heard a few minutes ago, the debate that generates the eBay decision regarding preliminary injunctions in the U.S. It's mostly a judicial decision that had some effects that you can whether be okay with them or think that they are very negative for the market or the patent system. The thing is that kind of same debate we are having it here right in the Andean community, but it's a normative debate because we have the Colombian norm specifying very detailed requirements and a very difficult, I would say, the standard to meet in order to get a preliminary injunction, which includes the proportionality and the necessity requirements. And in the other hand, you have the Andean norm that have more of a easy and automatic decision on preliminary injunction. It is not completely automatic, but if you meet a more simple requirements, a lower standard, which is that the patent holders proves summarily the infraction, the patent infringement, they will be allowed a grant with a preliminary injunction. So that debate is normative right now in the Andean community, and it's very interesting, at least from an academic point of view. It's very interesting because we had a narrative for so long here in Colombia and Andean countries that we have a complete harmonized system between national law and supranational law. And that kind of understanding is being challenged right now with this issue. And just to clarify, we don't have a decision from the Andean Secretariat. The Andean Secretariat gave its opinion on the matter, which is that the Colombian law is infringing Andean law, and that the Colombian law should be modified, or at least not being used by judges. But for what I've been seeing right now, it's that we were depending on an actual decision from the Andean court, the Andean High Tribunal, and they are the ones that will decide if whether Colombia is on infringement of the Andean law or not. And as I told you, this is very interesting because it broke the narrative that the Andean norm, it's very harmonized with the locals norm, and this is a very it's a great debate, and I can see points of view from everywhere in this debate. So Enrico, I don't know if you had to.
Oh, just to add something. I mean, of course, I'm not an expert on the Colombian law, but I have observed from abroad the developments and this debate, let's call it like this, between the courts, especially the Bogota court and the Andean community body. I mean, I like the idea. I mean, the principles established, no, by the court, by the Bogota court. I think that relying on proportionality and public interest factors when it comes to granting or refusing or conditioning an injunction, it's good, because I mean what the Bogota court did was to take into consideration consumer access and market disruption, right, in the proportionality analysis, as far as I understand. And I think this is good, because it's always the need of balancing two opposing interests is always there. It should be there. So I welcome this development, this latest development in Colombian case law, because it puts it a bit closer to the international scenario, to the international consensus that we have around injunctions. Then, of course, it remains to be seen how this debate between the Andean community body and the courts in Colombia will be resolved. Because, as you said, Juan Camilo, as we know, Laura, the decision is not binding, no, by the Andean body. So I don't know how it will evolve. It will unfold.
It will be interesting to see how that plays out. Thank you for your perspective on that. I want to encourage members of the audience, if you have any questions, to please put them in the chat, and hopefully we'll be able to get to those at the end. But in our final 10 minutes, I was hoping that we could go around and everyone could tell us what they believe to be the most important lesson other jurisdictions should take from Colombia when designing their own approach to SCP enforcement and balancing local procedural fairness with global litigation strategies. Laura, can we start with you?
Yes, Amanda. Balance, I think, is a key word. As we moved from the layers that David was explaining earlier, from a simple patent law to a patent law that needs to be balanced with competition law in terms of standardization processes, and setting and exclusion and cartelization. And as we add the layer of contract law and the SEP owner's commitment, et cetera, I think that what is important to maintain in both the procedural laws and the policy making and how the judges are deciding this matter is with balance and with all these layers of laws and of matters in mind. We didn't get to that point earlier, but Enrico touched it just a minute ago. Public interest is also important. And some of our judges have been deciding, I believe it was a denial of our preliminary injunction. And one of the judges said, I think this goes against consumer rights. And I think it was a very short decision, not well developed maybe, but it was interesting to see that perspective coming into what we started to believe at the beginning of the proceedings. This is a patent law matter, and it's not. It's a matter of balance.
Thank you. David?
So I think what's important is that we need to, things are spiraling out of control in SEP litigation globally. We are now, I think 5 years ago, when I told people I was in SEP litigation, licensing and policy, if I'd tell IP lawyers, they would ask what a SEP is. Some of them might know. Now, when I tell any commercial litigator I do SEP work, they go, "Oh, me too." And we are seeing a metastasization of litigations all over the world. We're now seeing in South Africa, Nigeria, Morocco, Vietnam. This is just in the past few months. And I think we are reaching a breaking point where the transaction costs of the global SEP licensing and this sort of rush for monetization is really going to start undermining and impacting standardization efforts. I think recently we saw HP and Dell stop including hard coding of HEVC into their standards. LG was looking at not adopting new digital TV formats. We've seen the problems with Dolby Vision. Like there's just a lot going on, and I think what I've seen from from many of the Colombia's judges is a real understanding that even when the broader issues aren't being brought before them, the awareness that the courts shouldn't be used as simple pawns and as part of bigger disputes. So I think that is the direction we're going, and hopefully we'll see the prudence we've seen from much of Colombia's judiciary going forward.
Great, thank you. Carlos?
Yeah, to the public policy question, what you should be learning from Colombia is, I think IP was designed to protect innovation, to protect local innovation, in particular, if you're looking at your country. So if you're Peru, you're Ecuador, you're Chile, you're Argentina, Brazil, how do you ensure and send the right message? Protecting your IP should not be a weird thing. You shouldn't be accused of being a weird, retrograde jurisdiction like's been tried and attempted in the UK concerning Colombia. Lenovo filed a witness statement saying, "We are too weak, we are not knowledgeable, we are dumb." That was a message sent to the judiciary. I think that's something we should learn. We have the right to apply our IP. And if you get a patent in Colombia, it's to be used. It's not something pretty to be put up on a wall. You got to be able to take care of it. Now, as to balance, yeah, we should obviously take care into account. If you're going to be seeking a preliminary injunction, you should take into account factors such as proportionality. But given it's my case, that's the one I filed against before the Andean Secretariat. Specifically, what we were asking for is there are very specific elements in Andean law that preempt domestic law, period. Don't make up stuff that's in the local law. If you want to take the elements in Andean law and start getting creative, so be it. And you can do that. And that's how we have periculum in mora in the Andean law, even though it's not expressly contemplated, but the Andean Court of Justice has adopted it. So I think it's an issue of balance at that point, but in no way should using Colombia or Ecuador or Peru or Chile or Argentina or Paraguay or Uruguay or any other little country, because that's the vibe I get from UK, judges and lawyers many times. It's like, you're something like lame jurisdiction where you're not allowed to touch, any of this super cool stuff and lay off it. And that's kind of, think about your jurisdiction as a very powerful leverage to be in the list. Colombia is now on the list with Germany, UPC, the US, Japan, India, and we're being used. And I think that's perfectly legitimate.
For what it's worth, Carlos, I would never call you weird or retrograde.
No, the courts, the judges. That's what the witness statement said, not me, the judges. And that's what was a bad sign.
My comment stands.
I was Kirkland. Don't worry, it wasn't WilmerHale.
Well, Enrico.
Well, as I said, for other jurisdictions, the message from this decision of the Colombian courts is that proportionality, public interest considerations, and some avenue for sensitive relief should be embedded from the very beginning of the negotiations. Doing so, I mean, would protect implementers, of course, from disproportionate market exit risks. It would encourage earlier and more balanced licensing negotiations and reduces the temptation for some SIP owners to treat this course as tactical outliers, I would say, in global strategies. So, in short, I think institutional durability depends on aligning strong enforcement, of course, with, on the other hand, transparent, fairness-oriented procedural safeguards. That's the main message.
Thank you. Juan?
Oh, well, I think pretty much everything has been said. I would add just a very local overview of this whole scenario. It's how the Colombian judiciary and Colombian courts end up after dealing with this very complex case. As I told you, that there was a narrative that the Andean law and the local norms are very harmonized, that it's kind of under question right now. Now, the other thing that was a narrative is that the Colombian courts were a very under-prepared courts that could not deal with complex cases regarding technology or regarding global litigation scenarios. And I think that what came out, whatever the result of this litigation is, what came out of this is that the Colombian judges are very well prepared and the Colombian judiciary system is very well structured in order to receive this kind of complex, as David put it, complex cases that has contract law and competition law, intellectual property law, of course, and very, very technical arguments that are being dealt by the parties in the files. So for me, the big lesson here is how well Colombian courts, and I would say at least in the main venue, which is Bogota, it's very well prepared to deal with this kind of scenarios.
Great, thank you. So that final point brings us to our formal discussion to a close. On behalf of all of us watching, I want to extend our deepest gratitude to our remarkable panelists, Juan, David, Enrico, Laura, and Carlos. Thank you for your time and for offering your expertise and to our discussion. And thank you to Juan and Javierina University for coordinating this webinar. To our audience, thank you for your time. The level of interest today confirms that Colombia's experience is a crucial chapter in the global SEP landscape in FRAND. So stay safe, stay curious, and thank you for joining us. The webinar is now concluded. Thank you. Bye.
Thank you.
Thank you.
Thank you.
Thanks,
Bye.
guys.
Okay. We're all offline now. So thank you very much, everyone.
Yes, thank you.
Gracias, Juan Camilo. Thank you,
Thank you,
Amanda.
Camilo.
Thank you,
Gracias.
Laura.
Bye. Nice to see you all.
Bye-bye.
Bye.